Good morning and welcome to today's Ask a Pro webinar. Today's topic is real estate default. My name is Ben Hoen and I'm joined by shareholder Casey Hicks and Ricardo Johnstone, who's an attorney at Weltman Cincinnati office. And we're going to start with some introductions. I am the managing shareholder of the real estate default group at Weltman. I've been with the firm for almost 20 years. And presently, I'm in the Cleveland office. During my tenure with the firm, I've concentrated on real estate default and have been helping clients to solve all sorts of foreclosure-related issues. Now let's turn to Casey and learn a little bit more about our Chicago office.
Good morning, everyone. I'm Casey Hicks. I'm also a partner at Weltman, and I am the office managing attorney of the Chicago office. We have gray skies outside today. I also work on real estate default matters outside of work. I am obsessed with Taylor Swift music and so excited for the new album coming out tonight. And I also love to run, and my next race is the Berlin Marathon in the fall. And I hope I have seen some of you before on my webinar that I host, Coffee with Casey, which Ricardo has been a previous guest.
Great, that is awesome. Thank you, Casey. Now let's turn to Ricardo and learn a little bit about our Cincinnati office.
Hi. I'm, like Ben said, I'm in our Cincinnati office. I'm a senior attorney here and have been with Weltman for a little over 10 years now, primarily in the real estate default group. I'm licensed in Ohio and Kentucky, and I also oversee our out-of-state network where we receive referrals for states that we don't have licensed attorneys in. Unlike Cleveland and Chicago, it's bright and sunny here in Cincinnati today. Hopefully we'll get to the 80s. Yeah, that's about it.
Amazing. Thank you, Ricardo. Before we get started, I would like to take a moment to go over a few housekeeping items. As a reminder, this is an interactive session. We're here for you. We want to hear your questions. Please submit those through the question button in the control panel. We're going to address as many questions as we can during the presentation. For those questions that we're unable to get to during the presentation, we'll certainly be sending responses following the presentation. Keep in mind the webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all the attendees. There will be a short survey on your screen at the conclusion of the event. Please take a moment to respond to the survey and share your feedback. We do greatly appreciate hearing your opinions on our webinars. It's very helpful for us in the future to present information that our clients want to hear and talk about. So without further ado, let's get into our first question here for Ask a Pro. Casey, I think I'm going to throw this one out to you. What are the next steps when you have attempted and exhausted all efforts to obtain payments with no success? What's next? When should mortgage servicers start to think about getting counsel involved?
All right, good morning again, everyone. Happy to take this first question, Ben. One of the most important things to keep in mind if you're looking to file a foreclosure suit on a defaulted mortgage loan is the Consumer Financial Protection Bureau's 120-day rule. With that rule, it indicates that the first notice or the first filing under a state's foreclosure law can't occur until the loan is more than 120 days delinquent. That delinquency date is determined, it begins on the first day that a mortgage payment is due and not paid. Within Illinois, where I'm licensed, there are no state required pre-suit notices anymore. We used to have what was called a grace period notice that was required to go out. That would not have been able to be sent until 120 days delinquent. Fortunately for us here in Illinois, we don't have to deal with that anymore because that statute has sunset. So any notices that would go out would not be a state notice. It would be either the MVN required pursuant to Regulation F or any pre-suit notices that are required by your mortgage document. Ricardo, I'm not sure, are there any pre-suit notices in your states?
There are not in Kentucky or Ohio. Same, it would be based off the mortgage docs. I know Indiana does have one, but the majority of states I've seen, it's just the mortgage stocks.
Yeah, one of the special states out there is Pennsylvania. They have a complex pre-foreclosure notice that has to go out called the Act Notice, which of course gives borrowers a lot of information that's helpful to them in trying to resolve foreclosures, because there's some federal funds still available in Pennsylvania. And we'll touch on that later in today's conversation. So why don't we head to the second question, and I'll throw this one out to you, Ricardo. How does someone submit a loan that is delinquent? Are there any special forms that are needed? What documents are needed? You know, now you're getting counsel involved, so let's discuss some of the regulatory issues involved at the outset of the foreclosure.
Yeah, it's really easy to submit a referral to our firm. We have a email fcreferrals@weltman.com. Send a referral there, it'll get processed. The group monitoring that will let you know if anything more is needed. But you can always email any of us on this. We'll make sure the referral gets sent to the correct group. We also have a redg global support.com email. If you send an email there, it'll get reviewed and sent to the correct parties. We do have a referral form. It's not mandatory. It's more helpful to the clients. If you see the form, you'll know all of the information that's needed. But like I said, it's not mandatory. Some clients have their own forms. So it's kind of just a preference. If anyone needs our referral form, just reach out to us and we can shoot it over. As far as the documents that are needed, that's why our form's kind of helpful. It lists everything that's needed, but generally we'll need the principal balance, of course, the loan docs, the note, mortgage, deed of trust, any loan modifications. We'll need a copy of your most recent periodic statement, payoff figures that include a per diem, the action in the name of, that's really important. Some of our clients may be servicers, so if we get a referral from them, but they want us to proceed in a different name, we know that. It's also important for standing reasons. We'll need to make sure there's a clear chain of title to the action in the name of. And that's it for the most part.
I would also add, sometimes it's important to know what lien position the client thinks that they're in, if they're in first or second lien position. That's important for us to know. So when we pull the title report, we can verify that you're in the correct lien position. And then also, like in Illinois, we have a lot of issues with deceased borrowers. So if you're aware that your borrower is deceased and you have a copy of the death certificate already, that would be very helpful on our end if that's sent with the referral materials.
No, I definitely, thanks for adding that, Casey. The lien position is important in case we ever have to review for a title claim or anything.
And title insurance policies are also helpful at the outset if one is available, because many times our firm would have to submit a title claim on behalf of our clients. And so definitely include as much documentation as possible with regard to that lien position.
One other thing, I'm not sure if Ricardo mentioned this or not, but sometimes the clients will send their own demand letters that are required pursuant to the mortgage. So if a demand letter has already been sent, you can send that over to us as well with the referral, and we'll verify that it was sent correctly. I know sometimes the mortgage document will require it to be sent via certified mail instead of just regular first class mail. So we'll just verify all of those requirements were met. And if they weren't, then we can obviously send a demand letter as well.
And just to dovetail on that, Casey, if there is a deceased borrower situation, if there has been a successor and interest identified, it's helpful to have that information in the referral as well, so that we know who we're communicating with, because we're going to communicate with the same person that the mortgage servicer has been communicating with. So again, more information, the better. Give your attorney a clean case, as I always like to say. So if we can set up a clean case at the outset, that helps us down the road and prosecuting the case for you. Let's head to the third question here. Sorry about that. And Casey, I'm going to throw this one out to you. How would you recommend that a servicer handle loss mitigation efforts during the foreclosure process?
All right, there's a couple different ways that this can be handled. A lot of times we will take direction from the clients as to how they want to handle loss mitigation. So there's a couple different things that could come in: requests for a payoff or a reinstatement letter. What I always like to ask the clients when we get those requests, especially if the good through date that we're getting is like a couple of weeks out, if the foreclosure is right where we're about to hit another milestone and obtain additional court costs or attorney's fees are going to be assessed, it's nice to know, does the client want that file on hold while we wait to see if funds come in for reinstatement or payoff? So there's that option. Other options are if the borrower is interested in just, letting go of the property, we can review the file for a deed in lieu, which would potentially give the lender title to the property without going all the way through the foreclosure process. That type of loss mitigation would also be determined on the title report and the lien position, because if you're in second lien position, the client would take title to that property subject to the first. If there's any sort of government or tax lien, a lot of times those would need to be paid off. Any junior liens additionally would need to be paid off because they're not foreclosed, obviously. You could also do an option of a consent foreclosure to get you that deed a little quicker as well. Those junior liens would have to then pay off the client to have the ability to continue with their interest in the property. But tax liens cannot be eliminated through a consent foreclosure. Then there's any other additional programs that different banks or lending institutions have. While the borrower is going through that process and submitting the application, it could take several weeks for them to get all the documents in. So it's really kind of a business decision. Like, there's two different tracks going on: the foreclosure process through the courts, and then also the loss mitigation. And it's, do you want to proceed with both at the same time? Do you want your file on hold to see if the loss mitigation can go through or not? When there is like a forbearance or a trial forbearance, then definitely we would want to put the files on hold during that time. In Illinois, we also have like mandatory mediation programs and things like that, where we can't even move the file to judgment until the account and the case actually goes through those programs. So a couple of different options for loss mitigation, modifications, and things like that. It's kind of case dependent too, where you're at, and obviously like what you want to do as the client, which we would always take direction from the client.
Those are such great points, Casey. Staying on the topic of trying to resolve the foreclosures, which is, obviously at an early on point in the foreclosure process, very important to our clients. Let me throw this one out to you, Ricardo. What are some of the avenues to pursue to resolve the delinquency when an owner cannot bring the loan current but wants to work out a solution?
The most common one I'd say is loan modifications. The client receives a complete loss mitigation application, reviews it, the member, the borrower qualifies, and then the loan modification can be completed. Once the trial mod payments are made, then we generally we would dismiss the action. Another option is forbearance agreements. Sometimes I see clients allow the borrowers to bring it current through maybe a 6-month, a 12-month repayment plan, and then we just do a forbearance. In some states, it's no issue that the courts aren't really there to rush you through the foreclosure. In Ohio, I have one county in particular, Montgomery County. They make you move everything really quickly. So we would be required to file a motion for stay, or the court may even dismiss the action without prejudice due to the delay. So that's something to think about. Of course, I would alert you of, hey, this is Montgomery County, that they're not going to let us not move forward to judgment. Another one, as Casey touched on, is deed in lieu. That's a good avenue if the lender wants to take ownership of it without all the time delays and everything of a foreclosure. As Casey added, you would definitely want to make sure to review the title. We would review it, make sure everything's clean, whether there's other liens, senior liens, taxes, any potential issues. Those are the primary ones I see. I'm not sure if you see any others commonly.
Something that I've been seeing a lot lately, obviously with the strong real estate market, is people are putting their properties up for sale to get out of foreclosure. They've got equity in the property. And what I would encourage clients to do is communicate early and often to find out if, in fact, the mortgagor has put the property up for sale. Maybe get a copy of the listing agreement, and then you can make your decisions in the foreclosure based on the progress that they're making to sell the property. Obviously, you want to keep the pressure on the borrower and the realtor to get the property sold, and by moving the foreclosure through the process at a steady pace, that seems to occur. But at the end of the day, it's a better result to get the property sold through a private action than necessarily having to go all the way through the foreclosure process and bringing it to sale. So, you know, every market is a little different, as realtors like to tell you, and we're fortunate that right now the market is pretty strong, and so that seems to be the number one way people are getting out of foreclosure these days if they don't have the resources to save the property.
Yep, I agree. It's surprising. I'm surprised sometimes. Hear nothing, the entire foreclosure action. First time I'm contacted is, hey, we have a closing date set in a week. It's like, hey, we could have passed this information along. We could have maybe held off on some of the action. But I agree that that is the number one way to have seen foreclosures get dismissed.
And communication is always key. That is really good, important information, Ricardo. Let's move to the next question. And Casey, I'll throw this one out to you. If a mortgage is breached, it is required that payments from a third. Is it required that payments from a third party be accepted, even if it's not enough to cure the breach? So dealing with non-borrowers.
Yes. So it's not required to accept payments from a third party. There could be some risk involved with that, potentially creating a relationship between the lender and the third party. Additionally, I would not recommend, especially if a reinstatement letter has been out and the mortgage is breached, I would never recommend accepting payments unless it's to cure the breach. If you send out a reinstatement letter, then only full reinstatement or payoff should be accepted at that time.
Yeah, that's a pretty good piece of advice there, Casey. Ricardo, have you seen anything in cases that you've handled on that issue?
No, I completely agree with everything Casey said. I always recommend not taking less than the full amount to cure the default.
Perfect. So let's head on to question 6. What are the general steps of the foreclosure? What are the milestones? Let's talk about judicial versus non-judicial type foreclosures. Ricardo, why don't you start out with this one?
All right. The general overview is a judicial action is what it sounds like. It's something in the courts, in the court system. Non-judicial action, for the most part, not in the courts. It's handled through recording. So in a judicial action, you'll have a complaint that's filed. You'll then serve that complaint on all the interested parties or all the parties that are required to be named in that particular state. Once service is complete, all the parties that were served have, it's called an answer period. Generally, it's about 30 days. Once that answer period expires, the next step would be to move for judgment. If they filed an answer, in most states, you move for motion for summary judgment. If no answer was filed, you move for motion for default judgment, just letting the court know no one's disputing this, you know, let's get judgment. After judgment's entered, states vary. States vary in everything, but here in Ohio, you would file a precipice asking for sale. Same as Indiana, you file a precipice. In Kentucky, when you get judgment, they automatically send it to the master commissioner to set a sale. But after sale or after judgment, the next step will be getting a sale date. Sale date set, it's held. Depending on the state, there may be a confirmation period. It may be sales the last step, but then whoever is the winning bidder, then they'll get the deed. Non-judicial, in my opinion, much faster. In most states, we get the referral, maybe have a notice of default recorded in the county, issue a notice, and then in some states, it goes straight to publication and sale. There is no formal service by process servers. It's the non-judicial in the states that allow it, it's a much faster process.
Ricardo, let me ask you, we had a question that came through. Would you give any advice differently to a servicer who is handling a second mortgage as opposed to a senior lien when it comes to commencement of the foreclosure and how to handle that foreclosure?
Yes, well, if you're a junior, first is of course the best position to be. But if you're a junior mortgage, especially now with the equity being so high, you'd really want to, of course, when we get title, review it, see who's ahead of you. Okay, if the senior lien isn't owed that much and the property's worth a ton, it's easy. Let's proceed. Depending on the state, some states you name everyone who has an interest in the property, whether they be senior liens, junior liens, etc. In other states, if you're a junior, you don't even name the senior because your foreclosure is not going to extinguish their lien. So it's important to let the lenders know, hey, if you do foreclose and you purchase this property, these senior liens are still going to be there. So it's important to know, hey, if you purchase this, you are going to have to pay off these seniors. So just something to think about. The property values as they are, a lot of times after the numbers are ran, it makes sense. Hey, let's proceed from junior. We'll get paid off. If a third party purchases it, they pay us off. They purchased it subject to the senior. Or if the senior is listed, it's going to sell for enough to pay off the senior and us. We both get paid through the sale proceeds. If you look at it the other way though, you're junior and you get your appraisal and this property is not worth barely enough to pay off you, you might want to think about, hey, do we really want to initiate a foreclosure, incur all these fees and costs? It goes through sale and then it only pay off the senior and you recoup nothing because the property value was too low. Fortunately, right now, I haven't seen that in a while, but it is something to think of.
Yeah, those are important things to think about. What about some of the pitfalls of being in the second lien position? How important is it to keep your eye out for foreclosures filed by the senior lien holder?
Yeah,
I'll jump in. Oh, sorry, Ricardo.
No,
I was going to give you a break. I'll jump in on that one. Especially, it's important to review those senior foreclosures if you are served as a junior lien interest. In some states, particularly in Illinois, you have to participate in that senior foreclosure by filing an appearance and answer and approve up affidavit in order to potentially claim any surplus at that foreclosure sale. If you kind of just sit on your rights or sit on your hands, as I like to say, and not do anything and just wait until the end to see if there's a surplus, a lot of times judges won't allow that here in Illinois. So you do have to participate in that lawsuit. So it's important to look out for those notices that you receive when you're served with those senior foreclosure actions.
Yeah, that's so true, Casey. So let's turn our attention to question 7. What is the timeline from start to completion of a foreclosure? how does a bankruptcy affect a foreclosure that has been started? Why don't I throw that out to both of you, since this question really varies based on jurisdiction and potentially the court and the judge. And I mean, there are so many variables here, aren't there?
Yes, there
Yeah.
are. And in Illinois, I will say this varies greatly by even the county. For example, in Cook County, there's a mandatory case management hearing that is typically scheduled 60 or 90 days or so, maybe even 120 days after the filing of the case. And you cannot move for judgment prior to that case management hearing. The case management hearing is held. If it's stricken, then you can move forward with judgment like the next day. But if a borrower appears and indicates they're, working on loss mitigation, a loan modification, or something like that, that hearing's likely continued for another 60 or so days to give them an opportunity to do that before a judgment is filed. We also have counties in Illinois that have mandatory mediation programs. For example, in Will County, the actual summons that the borrower is served with includes a date for a mediation hearing. So we go through the mediation process before a judgment can be filed. Sometimes the client will have to appear at the mediation, either telephonically, sometimes even in person. So those two things that happen at the beginning, right after the filing of the suit, kind of hold up the timeline. Additionally, there could be service issues if the borrower has moved or we can't locate them. If they're evading service, we might need to file a motion for special service or proceed with service by publication. Additionally, deceased borrowers, those kind of hold up the timeline as well. In Illinois and Wisconsin, there's a procedure to appoint a special representative for a deceased borrower if there's not an estate that's been opened or a prior probate case where an administrator or an executor was appointed. That particular person that's appointed as the special rep conducts an investigation, tries to find errors of the borrower, which then those errors might need to be brought into the lawsuit, which holds up the timeline because then you need to serve those errors as well. A bankruptcy, if a bankruptcy is filed, obviously the foreclosure would then need to go on hold because of the automatic stay. And depending on if it's a Chapter 7 or a Chapter 13, or if a motion for relief is filed, the foreclosure would remain on hold until relief from the stay or dismissal or discharge of the bankruptcy. So that's kind of the issues that we would see in Illinois that kind of hinder the timeline. Once judgment is entered, we typically have a foreclosure sale around 3 months later, depending on when the redemption period expires. So those are some of the issues that hinder the timeline. I never like to give like, oh, your foreclosure will be done in a year or something, because there's just too many variables that we see. But those are some of the main ones that we see here in Illinois.
Fortunately, in Kentucky and Ohio, where I practice, we do not have most of the things that hold up cases in Illinois. We do have mediations, but they're not automatically set. The defendant would have to file, in most cases, a request for mediation. That request be granted, and then a mediation be set. We don't have a mediation stage per se that you have to always go through before you can move to judgment. So in Ohio and Kentucky, it's very rare that you have a foreclosure that takes over a year. I know there are certain states through my forwarding program that take much longer. A state like New York, similar to Illinois, has a conference stage, and you can't proceed until you're released from conferences. Their courts are also backed up. So depending on the court, you may have a court delay in certain jurisdictions. Okay, the next hearing, you guys have something in 3 weeks and a month. Other courts, hey, we can't see you guys for 6 months just because our docket. So that is definitely court delays is a big thing that holds it up. Generally, it's the larger counties are just, their dockets are so backed up, you can't get the court date or the hearing date until down the road. I do, though, on some small counties have issues where they just don't have the staff. County here in Ohio, after judgment's entered, you request a sale date. They only set like 3 sales a month. So you may request a sale date and not get the sale date for 4 or 5 months, where it's just a long delay, everything else moved timely. Then due to the sheriff's office having essentially one employee, there's a long delay. But for the most part in Kentucky and Ohio, not too long. Very rarely does it go over a year, unless there's a long court delay issue or something's going on with service. Similar as Casey said, bankruptcy in all the states is going to stay the foreclosure.
So it sounds like one of the major delay sticking points in a lot of locations is the mediation programs that some of these courts have in place. What are some strategies that you can suggest to get through that process as quickly and efficiently as possible?
What I would recommend is, if the borrower has submitted a loss mitigation application, to ensure that that application and all of the documents that are submitted with that are reviewed timely, and a response is given to the borrower prior to the mediation date. A lot of times what we'll see is, we'll appear at the mediation and maybe the packet's not complete. The borrower wasn't aware the packet wasn't complete. And so then we're, coming back again in maybe 30 days to see if a complete packet has been submitted and reviewed. So it's just kind of staying on top of, the documents, and getting timely responses to the borrower would help move the mediation hearings along quicker.
Yeah, very important. Ricardo, what would you suggest to move it along in the process? Ricardo, I think you may have frozen. We'll see if we can get the technical glitches. Okay. Give him a second to see if he can refresh his camera there. It was a sunny day in Cincinnati, but it's cold in Ricardo's office. All right. Sorry, folks, for some technology glitches here. Well, Casey, while we're waiting, have you ever seen HELOCs in a first lien position, and how would you recommend for clients to handle those?
Sometimes I have seen HELOCs in a first lien position. It's rare. It usually kind of spikes my interest because it makes me wonder if there's some sort of title issue that's coming. So I do always review those title reports with a little bit more of like a keen eye, just looking out for issues. A lot of times HELOCs don't get shut down properly and they get ran back up. Me and one of the attorneys in my office were actually reviewing an issue like this yesterday on one of our files. If a HELOC is paid off and not shut down, and then the property is sold to a third party with a new lender, there could be issues about potentially foreclosing that because it wasn't shut down properly. There's also issues where that then second lien could potentially jump, or that HELOC's no longer a valid lien on the property. The client would have the option of obviously suing on the note, but those HELOCs can be tricky if they don't get shut down properly.
Sure. Yeah, it's always important to review the file to see if a close letter was received. A lot of the contested litigation that I've seen over the years really turns on that very important piece of evidence as to whether or not that close letter was issued. We talked a little bit before about loss mitigation alternatives. How would one go about clearing liens in order to pursue a deed in lieu? I know liens can make deed in lieus difficult. What would your recommendations be?
So a lot of times it's going to depend on where they're at, right? So if the client's in a junior lien position to a larger mortgage, it doesn't really make sense to kind of want to pay that senior lien off. But if they're junior liens, like say a water lien on the property for maybe $500, we could contact that lien holder and obtain a payoff for that small amount. There could be other like judgment liens for credit card companies or things like that might have a lien on the property, and they might be willing to take a short payoff for whatever their lien is, which is also something that we could potentially pursue to do on behalf of the client to clear that lien out for a deed in lieu.
Great. Yeah, very important because liens can make it a sticky situation when you want to negotiate a deed in lieu and didn't know there were any liens out there. You run title, and then all of a sudden, it creates another layer of work for everyone to try to clear that title. So, good advice. So, why don't we talk a little bit more about bankruptcy? If a borrower doesn't reaffirm the debt, what would your recommendations be in that situation?
If the borrower hasn't reaffirmed the debt through the bankruptcy, we would obviously still need to obtain relief from the stay within the bankruptcy court before we could proceed with any state court remedies. We would not be able to then pursue a personal deficiency, obviously, through the foreclosure because they haven't reaffirmed the debt if they did, in fact, receive a discharge through the bankruptcy. The most important thing for us moving forward with a foreclosure in state court after the filing of a bankruptcy is just to make sure we have that relief from stay order or a dismissal order.
And the debt would be discharged if the discharge order goes on, so we couldn't pursue anybody for money, but the lien still remains. And so would you recommend at that point that the servicer consider foreclosure?
Yes, most definitely.
Excellent. Why don't we move on to question number 8? Casey, I'm going to throw this to you. How do title issues affect the process and how are they resolved? Can you share some common examples? And I think we touched a little bit about that, but if you have anything else to add.
Okay, so some common title issues that I see are unknown senior liens. A lot of times they'll be like a really old mortgage from like the 1990s, the 1900s, that was just never released. It's obviously probably been paid. It just was never released. So what we would try to do there is we would try to obtain that release, track down who was the holder of that senior mortgage lien, and try to obtain a release and record that release. Typically when it's an old mortgage like that, where it's most likely been paid off, we would go ahead and file the foreclosure suit, especially in Illinois, because we don't name senior liens. We just wouldn't move forward with judgment until we made sure that we had that release. Additionally, if the client has a title policy, we would file a title claim. We would submit a title claim to the title company, and once that claim is accepted, the onus would then be on them to clear that title issue. Other common issues that I see are errors in the legal description. Sometimes those date back to several deeds prior. We always confirm the legal description on the deed, on the mortgage, and on the title report that we get. With that as well, the first thing we would do is see if the client has a title policy, and if they do, we would submit that to the title company for resolution. If there's no title company or title policy, when we have an error in the legal description, we would ask the client permission to reform the mortgage, to correct it, to obtain the correct legal description. We would file that request for reformation within the foreclosure suit here in Illinois. So we would have a 2-count complaint to reform and then foreclose. Sometimes when the referrals come through, we have missing assignments of mortgages. Those typically we can draft those if it's just missing one in the chain of title, the most recent one. We will typically draft those for the client and send those for recording. We would obviously then need to wait for the recorded AOM before we filed the foreclosure suit. And then HELOC issues, which we already touched on, those I think are the most common title issues that I see.
Yeah, it's so nice that in a state like Illinois, you're able to correct a lot of these issues within the context of the foreclosure. But for those of you that are in states that are non-judicial, like Michigan, for instance, a lot of these issues have to be taken care of in a separate judicial action before we can commence the non-judicial foreclosure. So if there are title issues that do crop up in a pre-foreclosure posture, be aware that that could create additional costs and expenses outside of what may have been anticipated through the foreclosure proceeding itself, because separate litigation has to be ensued to correct those. So there's always something something unique, something different that can crop up, and that's why it's so important to have counsel involved that, and early on, to resolve those before we embark down the foreclosure trail.
Yeah, I'd just add, sorry, I got disconnected for a
Welcome
minute.
back, Ricardo. It's good to see you
Yeah.
again.
Everything froze and then restarted and wouldn't refresh, and had to do the restart the computer. So I'm back. But I agree. One of the things I hadn't thought about on the timeline earlier was in non-judicial actions, if there is that title issue, like you said, Ben, we can't proceed with the foreclosure until we first do it, in most cases, a quiet title action, which can be a large delay sometimes, depending, because it's a judicial action clearing a title issue before we can even proceed with the foreclosure.
Yeah, so very important to keep your eye on that because it can affect the timelines for the foreclosure proceeding. Ricardo, why don't I throw this one out to you? Since we're talking about delays, what are some of the delays with respect to completing service?
Definitely a common one is the defendant evading service. They won't, if the state or the county allowed certified mail, they won't sign for the mail. If a process server is at their door knocking, they won't answer the door. They'll avoid them in all ways to get service. Sometimes in states that have dower, there are not many of them left. Ohio, Kentucky do. We have to name an unknown spouse. So we don't even know who this person may not exist, but because of a dower interest, we name an unknown spouse. It's hard to serve an unknown because obviously they're unknown. So some routes, or if they're deceased, unlike Illinois, we don't have to open a probate, but we'll have to name the unknown heirs. There's no one really to serve, so we know we're going to have to, at some point when service is complete on all the other defendants, we're going to have to do service by publication, which will be a delay. It has to be served, at least in Ohio, 3 consecutive weeks it has to be published. So you're going to have an additional about a month, 6 weeks of delay on serving that party. For unknowns in Kentucky, we have something called a warning order attorney, where the court appoints an attorney to work to serve this unknown. That can be a big delay because it's a court appointed attorney. You can follow up and say, hey, what's the status? What's the status? But we have to wait until they file their report showing everything they've done to try to serve this party. So sometimes it's out of our control. That's the toughest thing. We're doing everything we can to locate this. We're running skip traces. We're trying to find all the possible addresses. Sometimes we know we have a good address. We just can't serve the person. But some states allow service by sheriff. And not surprisingly, a lot of people are much more inclined to open their door when it's a sheriff knocking versus a process server and just plain clothes. So those are the most common ones I see.
Ricardo, what are some things that mortgage servicers can do to help their counsel, as early on as in the referral to ensure smooth service?
Well, the servicer should always let us know any updated addresses. Generally, it's required in the mortgage. There's a term of notices. It has to be sent to, the property address or any other address, the borrower has provided you to send notice. So if the servicer already knows, hey, they're not living here, or hey, they don't get their mail at this address, we send all of our statements to this address, or, we've been informed they also reside here. If they give us that, then we know right away, okay, they've asked their notices to be mailed here. Great chance this is where they're residing. We can issue service at this address as well. And of course, if they've notified the lender, hey, send notices here, we need to, as part of our check, if the lender had already issued a demand, let's make sure this demand was issued to the address that it should have been. If the lender didn't and we're issuing it, we also want to know that information so that we don't send it to the property address when the lender had already been advised to send it to, you know, address X. So it's very important for us to know and if there's any other addresses that notices should be sent to.
Yeah, some of the best information usually comes from the borrower themselves. So if the borrowers do contact the lender and they provide new information, certainly pass that along to your counsel, because that can be very important in the foreclosure process itself. Casey, did you have something you wanted to add there? Or?
No, but I wanted to kind of just dovetail back to the last question, because I didn't
Sure.
mention paying the real estate taxes as part of title issues, which I wanted to make sure we hit on a little bit, because we've seen with a lot of the clients, we've seen unpaid taxes coming in now. So in Illinois, they're typically like 2 installments. And if the real estate taxes are not paid, they go into a delinquency period, and then they can be sold by the county. And if the real estate taxes are sold by the county and not redeemed, the tax purchaser can petition for a tax deed, and that wipes out all liens on the property. So the mortgage lien would be lost. So it's really important to keep up to date on the real estate taxes if they're not escrowed, to ensure that they're being paid timely. So that's another title issue I just want to make sure everyone was aware of.
That is great advice.
Yeah, we see that in every state. Not the exact same process, but important to check on, to monitor the taxes in all the states.
Correct. So true. Ricardo, circling back to service, can a borrower be served at their place of employment? Have you ever seen that?
Yeah, I've seen that. It's allowed in Ohio. It's common practice. Of course, you can't. It'd be the process server who would do that, and of course, they can't do anything to intentionally embarrass them or anything, but they can hand them a summons. Good thing in Ohio, some process servers are better than others. I've had one situation, someone was saying, no, that wasn't me who was served. The process server was great. Served them at place of employment, this address, here's his identification, here's what he looked like, here's what he was wearing. It was, and it's done by affidavit, so it's great. When he contested that, our response to the court was, here's the process server's affidavit. He's admitted he works here. Process server served him there. Here's his description. He meets all this. It was pretty easy.
That's great. Anything to keep the case moving along.
Exactly.
Let me throw this next question out to both you, Casey and Ricardo. What milestones take the longest? What makes it the most challenging to get to judgment?
I'll just jump in here first. I think service is one of our most difficult milestones to get everyone served, kind of for a lot of the reasons that we've already touched on, evading and not having a valid address and things like that. Also, resolution of title issues, which we kind of already talked about a little bit as well. And then that if there's a deceased borrower that we find out the borrower's deceased after we filed, there's just certain steps that we have to do to get that special administrator, special representative appointed. They then conduct an investigation. We then name additional heirs. There's just additional steps we have to take for a deceased borrower that hinders us getting to judgment as quickly as we would like.
I 100% agree. Service is the longest milestone. Occasionally, something unusual might take longer just because of the court delay, where we served them in 30 days, but now the court can't hear our motion for judgment for 90 days. Generally, service, if not, it's almost always due to some court delay and just a court that has their docket really backed up. As far as what's challenging to get to judgment, in Ohio and Kentucky, it's generally not too challenging. You get service complete, whether an answer was filed or not. We'll get an affidavit executed by the client. If there was an answer, the affidavit would include information, saying why the defense isn't a valid defense. We'll have a breakdown of the amount due. We submit that with our motion for judgment. Then the court will hear both sides. Lenders aren't foreclosing when stuff's not in default, so it's not normally the biggest challenge. Occasionally we'll get some opposing counsels, and they'll make it take longer, but it's still not the most challenging. They'll serve us with a lot of discovery, a lot of requests for documents, try to set as many mediations as they can. And it's more of a time delay than an actual challenge. We get the information that's needed, we provide it, and that's that. It's important that we get the information timely so that we can provide it to them, prior to the mediation, so that when we're at the mediation, everyone's already had a chance to review it. But as far as challenging, it's not so much challenging. It just could be some additional work.
So contested foreclosures certainly can be one of the, especially in judicial states, can be one of the items that cause delays in the foreclosure process. What are some strategies that you would suggest to avoid or streamline some of those contested issues?
Well, definitely when I get discovery requests first, I always call the opposing counsel and try to figure out, do you truly think you're going to find something? Is this just a stall tactic? Or if they're trying, sometimes it's like, hey, we just did it, but they really want to do some loss mitigation. So versus incurring a bunch of fees and costs, you can ask, hey, do you want to stay the discovery request until your client has submitted an application? Almost always they say, that's perfect. Let's not incur additional fees and costs that, will be recoverable from the borrower. Let's stay that. Here's what they really want. Sometimes it's, hey, really, they're working on getting the funds together. Can we get a reinstatement quote good through a few weeks? Perfect. Yeah, I'll get your reinstatement quote. Would you like me to stay the discovery? Yes. So normally a phone call, you can get a good idea of what they're really trying to do here. Is it just stalling to give them some more time? Sometimes it is just a time thing. I've had situations where I've been able to contact opposing counsel and say, hey, if he just wants more time, if you're willing to consent to judgment, we're willing to not set a sale for the 120 days to give your client the time they need. So definitely giving a phone call is normally the best route to get a good idea of what they really want to do, because almost very, very rarely do they really feel like, hey, my loan's current and this shouldn't have been filed.
Yeah, those are some great practice points. Let's go to the next question and throw it out to both of you again. If the case goes to sale, how is the bid determined? And what are the possible outcomes of the judicial sale? Casey, do you want to start with that one?
Yeah, I'll start off with that one. So here in Illinois, you have the option, the plaintiff always opens the bidding at the sale. So we get the opening bid from the clients. Now that could be the total debt bid, everything that was included in the judgment, plus interest up to the date of the sale. If there were additional advances made from judgment to the sale date, we just need to know what those are so that we can provide the proper support to those to the court when we go to confirm the sale. But if the client doesn't want to bid total debt, maybe they want to bid the property's worth less money, so they want to open with the fair market value or potentially even a little bit less than the fair market value to hopefully get some competitive bidding so that the property actually sells for a higher amount. But the plaintiff does open the bidding here in Illinois, so we always request the bid from the clients. Basically a business decision then at that point from the client if they want to do full debt, fair market value, or something else. You can never bid over the total debt. The max amount of the opening bid would be the total debt. And then typically if there's another bidder, they just bid $1 over, and that's kind of how it goes to start. Right. So results of the sale, either there's no other bidders, so the plaintiff is then the successful purchaser of the property, or the property sold to a third party. And if it was a total debt bid, then the client's going to be fully paid off by that third party's bid. Once the sale is conducted, we then have to confirm the sale. That's a motion that we file. We then appear in court to have the sale confirmed. And typically, if the plaintiff was the successful bidder, they would be able to obtain possession 30 days after the sale is confirmed.
Ricardo, what are you seeing in your states?
Yeah, in Ohio, and Kentucky, it's different. Both states, they have, in Ohio, it's done by sheriff, or it could be done by a private selling officer who is appointed by the court. We would file a motion to have a private selling officer sell it. I'm feeling like that's getting more and more common. The private selling officers do way more to sell a property than the sheriff. Most counties around me, the sheriff does nothing other than post a picture from the auditor's site that could be 10 years old. The private selling officers will have much more recent photos. They actually market it. Their websites are better, more able to. They get a lot more bidders. A good thing in Ohio recently, the sales also used to be in person, so you'd have to have someone physically there to place your bid, which limits the number of bidders to people who can be in, Hamilton County on a Thursday morning at 9 a.m. Now they're on, the vast majority, maybe almost all of them now, are online bidding. So anyone, you can have someone in California wake up Thursday morning and place their bid. The bid is determined for the first sale at 2/3 of the appraisal. So occasionally a client their total debt may not meet that 2/3. So they don't bid at all. The good thing is if anyone bids, a third party bids, we know the client's going to get paid off because their total debt's less than that bid. In Kentucky, there's also a 2/3. In Kentucky, it's a little different. The appraisal, it gets appraised, and then you have to bid 2/3 to extinguish the redemption period. You can bid less, but then there will be a redemption period. So my recommendation is, if your total debt's over the 2/3, bid that so you extinguish the redemption period. After the sale, it either go to third party or back to the lender. In Ohio, we do have a confirmation period. In Kentucky, it's a little different. It's done by the master commissioner.
How would your bidding strategies change if you were dealing with a junior lien position, if at all?
So we're foreclosing from junior?
Yes.
Yeah, you would want to take in account the amount that's due to the senior. Before the sale, often we're asked to, hey, can you obtain the senior's payoff? We can try. A common holdup we get is we need authorization to provide our payoff number. Seniors won't provide their payoff to us unless we get borrower authorization. The borrowers are not going to provide us authorization because we're foreclosing on them. So the best you can do is sometimes get it from maybe a credit report. A lot of the seniors, at least in Ohio, the seniors are named because they have an interest. Most of them, when they file their answer, will put in an amount that they're currently due as of that and an interest rate. So we can provide that information the best we can. Occasionally we can't get much information, so we kind of have to ballpark, here's what we assume it is. But they should definitely take that in account so that they make sure they bid enough where only the senior's not getting funds. Where they do this whole foreclosure, the bid's not enough to pay off the senior, their liens extinguished, our liens extinguished, and the client doesn't recoup anything.
Yeah, that's some great advice, Ricardo. Thank you so much. And I want to thank everybody on the call today for attending Weltman's webinar. We hope you found this presentation informative. As a reminder, a short survey will pop up on your screen when the webinar ends. Please share your feedback and let us know what future webinar topics you would like to see. I would also like to share that we have a complimentary library of over 40 webinars that you and your team can view on demand. Our collection offers information on a variety of topics such as collateral recovery, real estate, and bankruptcy, to name a few. We'll send you a link to the library in our follow-up email. Thank you again for attending. and enjoy the rest of your day.
Thanks, everyone.
Thanks.